51st day of trial in the fraud case against Dr. Reiner Füllmich. It is the second day of the defendant's final statement. He began with a legal notice. In the course of my final statement, I will prove that the chamber wanted to convict me from the start and thus commit judicial misconduct according to the defendant. Cum-ex perpetrators who cause damage amounting to 59 billion euros in Europe are not treated nearly as harshly as I am. How can I harm a company that officially never existed according to the defendant? The chairman interrupted him at regular intervals. Statements like, "We want to convict you," are said to be offensive. And the academic career of Professor Dr. Drosten is irrelevant here. Mr. Füllmich replied, "I am just going through the door," that they opened with Corona. Otherwise, they would have kept the files clean. Attorney Wörmer also responded that this serves the defense interest of her client. Furthermore, he should be released immediately. Good morning, little expectation, pretend.
Good morning, first of all. Not such nice weather today. Yes, I expect that Reiner Füllmich will continue speaking to me today. And the day before yesterday, we weren't quite sure whether it was still his defense speech or already his final words. I don't know exactly. It's already his final words. Oh, well, that could still drag on. And I think it will continue to drag on. Yes, let's see what happens today. I don't expect the judge to suddenly say you are free because we have realized that you haven't committed any crime. That would be too good to be true, but I don't expect that.
As I see it, he is accused of embezzling money. The money is there. The gold has increased. I can't see anything wrong with that. The client must be acquitted. And especially now at Easter, the client must be released. Now, as the verdict is within reach.
Do you think you won't decide for Reiner for me? But I think you must. So this trial can be stopped within one hearing by giving him an acquittal. And then everything would be fine. Are you convinced that he is innocent? Because I have followed all the matters for 5 years throughout the entire Corona period, and I have a very clear stance, a clear opinion. This client has a conscience. He still has a conscience, and he acts accordingly. And justice must prevail, otherwise we are all lost, and we cannot allow that.
Yes, today it will probably continue with the final statement, as I understood it. And I hope that Reiner will also stand up for himself a bit if the judge intervenes so early, because to me it's completely unacceptable to see any digression in the first 2 hours. I don't see it that way at all, and in my opinion he has no right to interrupt. But let's see, it will turn around.
Unfortunately, I didn't catch the applause. To whom was it dedicated? To the defendant, I assume. And why? Because he explained everything very well, so that one simply has to understand it, and he is in the right. Are you convinced? Now that he did not commit embezzlement?
Well, we know that the money is there. He did not commit embezzlement, and he explained everything so wonderfully. I can't believe that he is not being released immediately. Yes, that's my opinion.
Any aspects that were new to you, which he highlighted again in his final statement? Not really. We knew what he stands for.
It's impressive how Dr. Füllmich shares the knowledge and also educates the entire legal field here. It's truly impressive, and I would say the whole thing could be concluded in an hour. Acquittal immediately. Nothing else for him.
Do you consider the chairman's interruption to be proportionate and lawful?
That he kept interrupting him during the conversation? No. One gets the feeling he is against him. You have to be unbiased and first clarify how things are and be completely open towards every person. And afterwards you can determine how things are, right or wrong. What personally convinces you that Reiner Füllmich is innocent? Well, during the entire Corona period, I watched all the Corona committees. It touched me deeply because I knew I was not alone. It strengthened me greatly and carried me through this time. I had to close my textile business. That wasn't easy for me either. I just realized this can't be true. This is simply unjust.
Was there a new aspect that you weren't aware of, which Reiner Füllmich highlighted?
Not really. I have already looked at everything on the internet. I am well informed. And I think he does it in a very clear, precise manner. And he always remains objective. And he is right. He is truly right. It is understandable. Anyone who wants to know the truth just needs to look it up themselves. And then they will realize that this client, he still has a Christian conscience. And he intends to bring the truth to light. That is important to him. And today, as we observe in politics, lies are told from start to finish, because sometimes within 24 hours, the opposite is claimed. And we are not used to that. We want the truth, and we are honest people, or at least we want to be, or we try to be.
Yes, this is my first time here today, and I have already observed several court proceedings back then also with Judge Detmar in Erfurt. Back then, as well as today, I noticed that it's not really about justice, but rather about a certain procedure that now has to do with money. However, I can't really assess what the exact modalities are. So I'm not really into that, but it's about something entirely different. So it's about whether the Corona Committee, which Reiner Füllmich founded together with Vivian Richter, was justified in terms of societal processing or not. And whether it happened for a good reason or not doesn't even matter. Rather, it's simply a question of the freedom to initiate something like this. And he did that, and he tried quite early on to find the truth, namely by interviewing many different opinions and all people. And from that, an image emerged which, as it apparently must be seen today, the state didn't like back then, and still doesn't today. And that's why this procedure exists. Because when you experience Reiner Füllmich, you also know why one simply doesn't want to let him speak, because he naturally is a strong person who can, so to speak, fight against injustice beyond his own personality. And that impresses me. And I am also a bit affected because someone like him, who talks about the light, where we want to see it at the end of the tunnel, is allowed to receive so little of it.
Yes, well, I think it's really unfair what's happening there, especially our entire legal system in general, because you think a client, because of some funds, end up in pre-trial detention for a year and a half, and then when you think about it, such a defender sometimes gets released on probation for 1 to 2 years, which I think is somehow a bit unfair. And yes, exactly. And I also find it unfair that the lawyers are being threatened like that, because I think that can't be right. And because that's actually their job, that's their profession, that's what they learned. And why are they then?
What do you say about the interruptions by the chairman? He interrupts the defendant constantly.
Yes, I found it somewhat amusing, almost as a spectator, to listen to it, because I thought, in some respects, it wasn't justified at all. Yes. Okay, thank you.
Yes. It's super cool that such a young person like Patricia dares to be in front of the camera, especially when it's her first time in court. And I think that the spirit of the times also needs young trial observers as the next generation. And the people in whose name the verdict is delivered also include children. Yes, and I believe there's nothing against wanting to cultivate one's sense of justice from an early age. Thank you, Patricia. Ms. Wörmer, it is now the second day of your client's final statement. Your client stated right at the beginning of his final statement that he wanted to make a legal point, namely that the chamber could be guilty of perverting the course of justice, could be liable. And did I understand correctly that he wants to prove in his final statement that the chamber intends to convict him from the start and that a criminal complaint is also being considered?
Yes, he hinted at that. He had already mentioned it earlier during his, the final statement is divided here in the plea. He had already spent a few days as part of the plea before me and also before Mr. Simon pleaded. And he had already announced it then. I believe he also did so at the end of last year. A shorter criminal complaint was read out during the trial, which was directed against the chairman and the entire chamber. I'm relatively sure about that. Yes, and he announced it. He has also worked out quite a bit on it. And yes, we will see if he will also come to present all of that next week. Today he focused more on the topics Corona, also the pandemic and his committee work. And for that reason, he was reprimanded multiple times, unfortunately.
You, along with your client, also criticized the chamber, or rather the chairman, Jung, and requested that he justify it and that it should be recorded in the minutes. What was the reason for that?
Well, there were a total of 12 reprimands or warnings from the chairman today. They had different content. Partly it was about disparaging court personnel or private matters of court personnel that had no relevance to the proceedings here. So I believe it referred to, yes, always to Mr. Schindler, maybe once to someone else. That was not considered relevant to the decision. And essentially it was about the corona topics that I just mentioned, specifically the substantive work of the corona committee. It is still evident that these topics are absolutely important to Reiner Füllmich. And that's why I intervened at one point and explained that it is indeed relevant to show that the defendant did not act out of an anti-constitutional mindset, as is often said in criminal law, and did not invent anything to collect donations and then flee abroad to live a luxurious life. The suspicion was also supposed to be raised by the complainants, or this impression was to be created by the criminal complaint, with the law enforcement authorities quite clearly. But the opposite is true. The client has always acted here and has run this corona committee for years, a total of 2 years, and then even founded his own format after his expulsion, ICIC law. And he operated it until one day before his arrest, so to speak, or to clarify, in his view, injustices and above all, to present the lack of scientific background regarding the corona pandemic. And that's why he referred again today to this preliminary ruling from the INA, Higher Administrative Court of Osnabrück from last autumn. There was a preliminary ruling to the Federal Constitutional Court where it was also about the fact that the corona measures largely lacked a scientific basis and were rather politically motivated.
Now someone has said from the beginning that this is a political trial, and he suspects that they want to convict him from the start, and he can also prove it. To what extent is the interruption by the chairperson, claiming that these are offensive statements, legitimate if it is part of his evidence?
Well, the chairperson still denies that. He says there were no talks with the intelligence services. That was the point where Reiner Füllmich referred to the fact that the colleague Miser presented the dossier here from the intelligence services, and also said that there were talks with the judge from the services. Reiner Füllmich said this was assured by a lawyer today, and he therefore assumes that, of course, all of this took place. And the court, that is the chamber, still denies this and says it did not take place. And if it is alleged that they are supposed to pass a judgment at the behest of the services, this is denied by the chamber and specifically by the chairman because he was repeatedly addressed personally about it by Reiner Füllmich.
You also demanded quite energetically at the beginning that your client should be released immediately. How was he informed about this? Or was he informed about this because I wasn't there for the last 5 minutes?
No, in fact, there hasn't been a decision on that yet. It was again about the issue that in the legal notice from the chairman in May, there was the wording, in Lower Saxony, the instrument of electronic ankle monitoring is generally not available as a substitute for pretrial detention. So I added generally now, but that's how it was meant. And the client has now heard of cases yesterday in the correctional facility where it was apparently somehow decided by the prosecution as part of a discretionary decision that there is no electronic ankle monitoring as an alternative. It is said to have involved pretrial detention, so that somehow at least factored into the decision. And therefore he assumes that it is indeed generally available in Lower Saxony. I then, of course, reacted quickly and said, okay, then we naturally demand the immediate release with the application of electronic ankle monitoring as an alternative to pretrial detention. And then I pointed out the risk of flight again, because there is even a case law on that from the European Court of Human Rights that especially the reason for detention due to risk of flight generally opposes electronic ankle monitoring. The European Court of Human Rights has even decided that way. And you can also find that in the commentary literature, and that's why I'm exactly there. I have so far assumed that the risk of flight opposes this. And that's why I intervened and said the wife would then, if in doubt, immediately come to Germany, register here, and take up a permanent residence to eliminate the risk of flight. In this case, but We then inquired again if it should indeed be the case that not the individual circumstances of the case play a role, but rather that in Lower Saxony, electronic ankle monitoring is generally not used in pretrial detention. An alternative is, as the chairperson later clarified, we probably unfortunately have no chance with the application. But the application has been recorded and will, of course, also be formally decided. And I also requested a detailed justification.
Thank you for now. You're welcome. So a question, the accusation is embezzlement, paragraph 266. It states that one must not violate someone else's assets, or rather has a duty to manage assets and must not use the money for private purposes. Do you find it questionable that he used the donation for private purposes?
Well, firstly, the victims here were not asked at all. The potentially affected parties, namely the donors, were not asked. The people who wanted the money and not those who donated it were asked here. I don't even know if I donated myself. I have donated to various organizations, but if I had donated, or maybe I did, it would have been almost irrelevant to me what he does with it. People also need to know how they earn their daily bread, and he couldn't work for it either. He put a lot of work into it, and therefore I think even if he had used it, somehow it would have been justified. Actually, it would have been only fair and reasonable, but he didn't use it himself. The people basically lived off their own resources. And the fact that he secured the money is also understandable if you know the backstory that he had already had his accounts closed by people in Germany. And that was even before Corona. And then seeing how similar things happened in other institutions, it's completely understandable. And I don't understand why the court doesn't immediately realize this and says, well, of course you had to do that. But the fact that they stubbornly deny reality is another sign that this is a very contrived trial.
Are there also other opinions, like the opposing side might say, now he's blaming the state, the evil state, to enrich himself? What do you say to this accusation?
Yes, I mean, we saw during Corona that we really have to be careful about what happens with the state. And many people have seen their freedoms being taken away. And if you don't ask questions and say, as a citizen, I'm just the cash cow, I have to pay and others can do whatever they want, that eventually rubs people the wrong way. Taxes are increased and then you're told we have to go to war. Now even war is being reconsidered and everything is suddenly turned around so that people don't say, I once had an education like in 1984 or something where things were suddenly perverted. We still talked openly about it in school. And today people just say, no, but now the situation has changed. So you don't say, hey, I learned something once. I learned a fundamental understanding of morality and many other things, and I draw upon that. And I have to honestly say, Reiner Füllmich is absolutely 100% correct on that. This is something that was already partly the case before Corona. And with Corona, the ugly face of the state was revealed.
Yes, fortunately, your swelling has gone down a bit.
What is your feedback on today's day in court?
Let's put it this way. I actually love it when Reiner expresses something vividly. And today he said a beautiful sentence. For what they have done, the hammer will come down in a curse suddenly and unexpectedly. And that actually shows what makes Reiner who he is. That he says, okay, that's not a threat or anything, but it's actually karma in the end, an answer. And you're not worried that the camera might take it the wrong way? It has so much in the wrong throat that nothing else can fit in, I feel. No, actually, it's such that no matter what he says, they will somehow see it that way. If you don't want to hear something from someone, then you inherently misunderstand them. So I think it happens to all of us. When someone says something about us and we don't like them, we will always gladly misunderstand it.
What was your impression of the proceedings today?
The impression of Reiner now, especially the last 2 hours, my final statement or plea, if you want to see it that way, he was really in his element and laid it out properly. Like the illegality of the politicians and so on. He also laid out his work, what his work was. And, well, the judge admonished him several times. He should get to the point, or it has nothing to do with it. The defense sees it, we see it completely differently. Of course, it has a lot to do with the matter because it's about the Corona Committee, about the investigative work and so on. And that confirms, yes, the whole thing makes it credible that he is being persecuted here because he is critical of the government. This is also confirmed by the dossier and all these things. And of course, something like this belongs in the final statement. And that the judge He admonishes and prevents us. We are surprised that he intervenes so quickly here. The question is, what is he pursuing behind this? The defense must be very careful, and all of us, including the trial observers, should write everything down, and so on, so that it reaches the public. Because the final statement is sacred. So to intervene in these few hours like that, I find neither lawful nor proportionate.
Your client focused more on a phone call today, which took place on November 23rd, I believe, between the prosecution and the defense attorney of Vivian Richter, Mr. Wilhelmsheimer. From your client's perspective, this phone call is crucial because it is said to have been the catalyst for the existence of an alleged liquidity reserve. Can you say something about that?
Yes, well, Reiner, I noticed that the phone call obviously took place on November 1st, also took place. That was the date when we had the first detention review or presentation at the district court here in Göttingen, and where he was then directly rebuffed by the judge that his statement would not be of interest. So it was an affront. He was then able to express himself. Initially, he had the impression that he was not being heard legally. During the session, he pointed out the existing sole representative authority and the exemption from business conduct for the VGOG, which was repeatedly disputed because the prosecution did not have the documents at that time. Possibly the prosecution then, after this session, we don't know, but it is noted in the file on the same day, contacted Vivian Richter's defense attorney again and followed up there. You only see the whole picture later. Then there was apparently a letter to the prosecution from the defense attorney dated 23rd November, where he refers to this phone call and mentions it. And then he goes on to say that the loan agreements were concluded in the sense of a trust agreement. So there are no loan agreements, but in reality, they were trust agreements or a liquidity reserve. I don't have the exact wording of the letter in mind right now, but he apparently also submitted the affidavit from Reiner Füllmich, where Reiner Füllmich swears under oath that there have only ever been loan agreements and no trust agreement was concluded. And the whole thing was always intended and lived as loan agreements between him and Vivian Richter.
At some point, it also states that the defense is also not in possession of the complete file.
At that time, I believe Volume 4 was missing, which would have been crucial. Is that correct? So the fact is that in the indictment, Volume 4 or even Volumes 5 and 6 were mentioned. And we noticed this when we received the indictment on November 23rd. I believe we received it then. And as a result, I naturally requested the complete files. This means that until the indictment was filed, we could not fully defend ourselves and did not have full legal hearing because the defense did not have the complete files that the prosecution referred to in the indictment. Correct.
Good. Thank you very much.